Hello everyone, this is Dhanashri Chougale and you're watching Ganga Education. Welcome back to my channel. On this channel, you will get information regarding law and competitive examination related to law. So subscribe my channel and hit on a bell icon so that you can get information regarding upcoming videos. In this video, we are going to discuss a question paper of Civil Judge Junior Division Judicial Magistrate of First Class Preliminary Examination held in 2014. In 2013, there was no vacancies for this post. Now, this video series will be in 4 parts. We will discuss 25 questions in each part. This is first part and we will discuss from question number 1 to question number 25. So, let's get started. This is the question paper of Civil Judge Junior Division and Judicial Magistrate of First Class Preliminary Examination 2014 and question set number A. We have already discussed instruction for the candidates while discussing Civil Judge Junior Division and Judicial Magistrate of First Class Preliminary Examination 2011. So, we are not going to discuss in detail right now. Let's jump on question number 1. Question number 1. In an offence of criminal breach of trust by public servant, the period of limitation for taking cognizance can be condoned by option number 1, Supreme Court, option number 2, High Court, option number 3, Court of Session, option number 4, none of the above, and the correct answer is option number 4, none of the above. Question number 2. Stolen property seized by police can be returned by option number 1, police officer who had seized it. Option number 2, senior police officer. Option number 3, commissioner of police. Option number 4, none of the above. And the correct answer is option number 1, police officer who had seized it. Now question number 3. If a convicted person is sentenced again, general rule is that both the sentence will run option number 1, one after other, option number 2, together, option number 3, after appeal is decided, and option number 4, none of the above. And the correct answer is option number 1, one after other. Question number 4. If the court of JMFC, that is Judicial Magistrate of First Class, has imposed a sentence of fine of ₹75 only, and appeal may lie with the permission of option number 1, Court of Session, option number 2, High Court, option number 3, Supreme Court, option number 4, none of the above, and the correct answer is option number 4, none of the above. Now question number 5. If a woman sentenced to death is found pregnant, the execution of the sentence can be postponed by option number 1, Governor of the state, option number 2, Judicial Magistrate of First Class, option number 3, Court of Session, and option number 4, High Court. And the correct answer is option number 4, High Court. Question number 6. Offence under section 498A of the Indian Penal Code is compoundable, option number 1, with permission of court, option number 2, without permission of court, option number 3, with permission of the lady, option number 4, none of the above. And the correct answer is option number 4, none of the above. Question number 7. After the transfer of magistrate, trial of an offence under section 138 of Negotiable Instrument Act, option number 1, is to be conducted afresh by the new magistrate. Option number 2 is to be conducted from the stage left by earlier magistrate. Option number 3, the complaint has to be dismissed. Option number 4, none of the above. And the correct answer is option number 1, is to be conducted afresh by the new magistrate. Now question number 8. Prior to issuance of summons to accused, option number 1, the notice is required to be issued to the accused. Option number 2, notice is not required to be issued to the accused. Option number 3, it is discretion of the magistrate whether to issue notice or not. Option number 4, none of the above. And the correct answer is option number 2, notice is not required to be issued to the accused. Now question number 9, police can investigate non-cognizable offence. Option number 1, with permission of Commissioner of Police. Option number 2, with permission of court. Option number 3, with permission of Superintendent of Police. And option number 4, none of the above. And the correct answer is option number 2, with permission of court. Question number 10. Cognizable offence means option number 1, where police may arrest the accused without warrant. Option number 2, permission of court is necessary for arrest. Option number 3, police cannot investigate without permission of court. Option number 4, none of the above. And the correct answer is option number 1, where police may arrest the accused without warrant. Question number 11. In a money decree, option number 1, judgement debtor can create fresh bank account and deposit in it. Option number 2, can take a bank loan. Option number 3, the amount is sent to decree holder by money order. Option number 4, none of the above. And the correct answer is option number 3, the amount is sent to decree holder by money order. Now question number 12. If the suit is dismissed due to default of plaintiff and if there is subsequent suit between same parties, then decision in the first suit, option number 1, amounts to res judicata. Option number 2, does not amount to res judicata. Option number 3, amounts to stay of subsequent suit. Option number 4, none of the above. And the correct answer is option number 2, does not amount to res judicata. Now question number 13. In a money suit, the court can award, option number 1, the interest during pendency of suit. Option number 2, interest from the date of decision of suit till realization. Option number 3, interest prior to institution of the suit. Option number 4, all of the above. And the correct answer is option number 4, all of the above. Question number 14 is removed from this examination. Now question number 15. Issue is required to be framed for, option number 1, every fact pleaded by the plaintiff. Option number 2, every fact denied by the defendant. Option number 3, every material fact affirmed and denied by the parties. And option number 4, none of the above. And the correct answer is option number 3, every material fact affirmed and denied by the parties. Question number 16. Defendant has got right to begin as and when. Option number 1, the plaintiff wants. Option number 2, it is convenient to the defendant. Option number 3, the defendant has taken any special defense. Option number 4, none of the above. And the correct answer is option number 3, the defendant has taken any special defense. Now question number 17. Decree for restitution of decree may be executed by, option number 1, detention of judgment debtor in civil prison. Option number 2, attachment of property of judgment debtor. Option number 3, both the ways. Option number 4, none of the above. And the correct answer is option number 2, attachment of property of judgment debtor. Now question number 18. Commissioner may be appointed for, option number 1, examination of witnesses. Option number 2, local inspection. Option number 3, taking accounts. Option number 4, any of the above. And the correct answer is option number 4, any of the above. Now question number 19. Subsistence allowance is an amount which, option number 1, husband pays to the wife. Option number 2, employer pays to suspended employee. Option number 3, is deposited by the decree holder in the court if judgment debtor is to be sent to civil prison. And option number 4, none of the above. And the correct answer is option number 3, that is deposited by the decree holder in the court if judgment debtor is to be sent to civil prison. Now question number 20. Filing of an appeal. Option number 1 automatically amounts to stay of original proceeding. Option number 2 will amount to stay only when it is granted by appellate court. Option number 3 amounts to reversal of judgment. Option number 4 none of the above. And the correct answer is option number 2 will amount to stay only when it is granted by appellate court. Now question number 21. Wife can be compelled to disclose communication with her husband. Option number 1 in a suit between landlady or wife and her tenant. Option number 2 in a case between employee or wife and her employer. Option number 3 in a case between mother and son. Option number 4 in a case between husband and wife. And the correct answer is option number 4 in a case between husband and wife. Now question number 22. A found in possession of stolen car after the theft. Court may presume that option number 1 A is owner of car. Option number 2 A is driver of car. Option number 3 A is passenger in that car. And option number 4 A is thief. And the correct answer is option number 4 A is a thief. Now question number 23. When sword used for murder is produced in the court, it is option number 1 documentary evidence. Option number 2 oral evidence as to existence or condition of sword. Option number 3 material evidence. And option number 4 none of the above. And the correct answer is option number 2 oral evidence as to existence or condition of sword. Now question number 24. If a girl is begotten during 7 months and after dissolution of marriage wife remains unmarried, it is a conclusive proof that option number 1 there was a valid marriage. Option number 2 there was a valid dissolution of marriage. Option number 3 the girl is legitimate daughter of that man. And option number 4 none of the above. And the correct answer is option number 3 the girl is legitimate daughter of that man. Now question number 25. Registered will may be proved by examining option number 1 testator. Option number 2 beneficiary. Option number 3 attesting witness. Option number 4 a person from the office of sub-registrar. And the correct answer is option number 3 attesting witness. That's it for this video. We have discussed question number 1 to question number 25. In previous videos, we have discussed the Civil Judge Junior Division and Judicial Magistrate of First Class Preliminary Examination held in 2011 and 2012. The links of those videos are mentioned in description box. Please go through it. Don't forget to subscribe my channel and hit on a bell icon. Thank you for listening.